Welcome to this meeting of the Standing Committee on Social Development. Participants are abiding by social distancing guidelines or are participating remotely. Members of the public were invited to contact the committee clerk if they wish to appear before committee. I will now ask all members to introduce themselves for the record, starting with the member to my left.
Ron Bonitrus, MLA Decho.
Katrina Knockleby, MLA for Great Slave.
Rocky Simpson, MLA, Hay River South.
Lisa Semler, Inuvik Twin Lakes.
Thank you very much. And on the phone?
Kevin O'Reilly, Frame Lake. Thanks.
Thank you very much, Mr. O'Reilly. In the room today with me as well, we have Aaron Shea, Committee Advisor, Gerry Burla, Committee Clerk, and Toby Kruger, Law Clerk. This evening, the Standing Committee on Social Development is reviewing two bills. Bill 12, an act to amend the Apprenticeship, Trade and Occupation Certification Act, and Bill 20, an act to amend the Employment Standards Act. The committee will address each bill in its entirety individually. Starting with Bill 12, the bill allows for the issuance of other prescribed certificates, which would allow the Department of Education, Culture and Employment to issue a Certificate of Achievement in Business Competency to NWT journey persons commonly known as a Blue Seal Certificate. There is currently no mechanism for granting Blue Seal certificates under the NWT legislation. The amendment would make it possible for the minister to issue such certificates when requirements are met. The bill itself is available on the Legislative Assembly's website. The amendments would keep the NWT aligned with other jurisdictions where Blue Seal certificates or similar certificates are issued, such as Alberta, Saskatchewan, and the Atlantic provinces. They would also remove the reference to prescribed forms, allowing forms to be as directed by the director. The application forms referenced in the legislation would not need to be included in the regulations as they are now, which is impractical when a form needs updating. I will now invite the Honourable R.J. Simpson, Minister of Education, Culture and Employment, to open the proceedings on Bill 12. Following the Minister's remarks, committee members may make comments or pose questions to the bill. Minister Simpson, will you please start by introducing your staff for the record and proceed with any opening remarks that you may have on the bill?
Thank you, Madam Chair. I'm joined today by Rita Mueller, Deputy Minister, Michael Saturnino, Assistant Deputy Minister, Labour and Income Security, Sam Shannon, Assistant Deputy Minister, Corporate Services, Michaela Robertson, Legislative Counsel, Department of Justice, Ronna Sherrigan, Ministerial Special Advisor, and Julia Mott, Senior Advisor to the Deputy Minister. And I believe somebody may still be in the lobby. So I'm not sure if the clerk can ensure that all of the witnesses have been allowed into the meeting.
Thank you, Minister. Our committee clerk is just checking the lobby to make sure that everybody is in. And in the meantime, would you like to proceed with your opening remarks?
Sure. Thank you very much, Madam Chair. I'm here today to present to the Standing Committee on Bill 12, an act to amend the Apprenticeship, Trades and Occupational Certification Act. The Apprenticeship, Trade and Occupational Certification Act gives the Minister authority to issue various types of certifications for apprenticeship, trades and occupations in the NWT. This bill seeks to amend the Act to allow for the issuance of other prescribed certificates to give the Department of Education, Culture and Employment the ability to issue certificates of achievement in business competency to NWT journey persons, also known as a Blue Seal certificate. Blue Seal certificates, which are issued in a number of jurisdictions, formally recognize achievement in business competency when a journey person has completed recognized business courses and training. There's currently no mechanism for granting Blue Seal certificates under the Act. Having a Blue Seal certificate and program in the NWT that formally recognizes the achievements of journey persons in business competency would both support the growth of business and the continued professional development of journey persons. The amendment would also keep the NWT aligned with other jurisdictions where Blue Seal certificates or similar certificates are issued and encourage associated business education and training in the North. I'm pleased to bring forward these amendments that will have a positive impact on our residents and the NWT labor market. This concludes my opening remarks, and I would be pleased to answer any questions that the members may have regarding Bill 12. Thank you.
Thank you very much, Minister Simpson. Members, does anybody have any questions or comments for the Minister? Seeing none, I believe we are now concluded this stage of our review. Mr. Clerk, are there any requests from the public to appear before committee?
There were no submissions from the public, Madam Chair.
Seeing as there are no further general comments or witness presentation, does the committee agree to proceed to a clause-by-clause review of Bill 12, an act to amend the Apprenticeship, Trades and Occupation Certification Act? Agreed. The committee agrees to conduct a clause-by-clause review of Bill 12. Let's turn to page 1 of the bill. Clause 1, does committee agree? Clause 2, does committee agree? Clause 3, does committee agree? Clause 4, does committee agree? Does the committee agree that Bill 12, an act to amend the Apprenticeship, Trades and Occupation Certification Act, is now ready for consideration in Committee of the Whole?
I move that Bill 12, an act to amend the Apprenticeship, Trades and Occupation Certification Act, be reported to the Assembly as ready for consideration in Committee of the Whole.
Thank you, MLA Semler. Motion is in order. Motion is on the floor to the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Bill 12, an act to amend the Apprenticeship, Trades and Occupation Certification Act, will be reported to the Assembly as ready for consideration in Committee of the Whole. Committee will now consider Bill 20, an act to amend the Employment Standards Act. Bill 20 includes two provisions that will A, provide protection to NWT workers, and B, provide flexibility to employers during the COVID-19 pandemic and any future emergency. The first provision, emergency leave, provides job protection to NWT workers in the event of an emergency situation by allowing workers to access unpaid leave when they are unable to perform their duties due to an emergency. This provision encourages workers to comply with any public health best practices. The second provision will provide flexibility to NWT employers by removing additional barriers during an already difficult time. The amendment includes an exception to the legislated requirement to provide notice of group termination in the case of an unforeseeable event or circumstance. Employees will retain their entitlement to individual termination notice or pay in lieu of notice. This bill is also available on the Legislative Assembly's website. The amendments would allow the department to prescribe an emergency in the Employment Standards Regulation so that employees will still be able to access emergency leave when the state of emergency has ended. The second set of amendments provides an exception where an employer's inability to provide group termination notice is permissible when a significant unexpected event or circumstance occurs that prevents the employer from respecting the notice period in the Act. The exception would only apply when an employer is required to terminate the employment of a group of employees as a result of a circumstance or event beyond their control, such as the destruction or major breakdown of machinery or equipment, climatic or economic conditions, or emergencies including a public health emergency. I will now invite the Honourable R.J. Simpson, Minister of Education, Culture and Employment, to open the proceedings on Bill 20. Following the Minister's remarks, committee members may make comments or pose questions on the bill. Minister Simpson, will you please once again introduce your staff for the record and proceed with any opening remarks you may have on the bill? Thank you.
Thank you, Madam Chair. I think you said it all, but I will proceed with my opening remarks. We'll probably tread some of the same ground, though. I am joined today by my Deputy Minister, Ms. Rita Mueller, Mr. Michael Saturnino, Assistant Deputy Minister, Labour and Income Security, Sam Shannon, Assistant Deputy Minister, Corporate Services, Haley Matheson, Manager of Employment Standards, Laura Jeffrey, Legislative Council, Department of Justice, Rhonda Sherrigan, Ministerial Special Advisor, and Julia Mott, Senior Advisor to the Deputy Minister. I'm here today to brief Standing Committee on Bill 20, an act to amend the Employment Standards Act, and answer any questions members may have. This bill seeks to amend the Employment Standards Act to include two provisions that will provide protection to NWT workers and provide flexibility to employers during the COVID-19 pandemic and any future emergency. The first provision, emergency leave, provides job protection to NWT workers by allowing workers to access unpaid leave when they are unable to perform their duties because of an emergency, such as the ongoing public health emergency. This provision will not only encourage workers to comply with the public health best practices, but will also allow the NWT to meet its commitments to the Government of Canada under the Safe Restart Agreement and allow NWT workers to access the recovery benefits under the Government of Canada's COVID-19 Response Measures Act. The second provision will provide flexibility to NWT employers, removing an additional hurdle in an already difficult time by including an exception to the requirement to provide notice of group termination in line with the notice period set out in the Act when an unforeseeable event or circumstance beyond an employer's control occurs, preventing the employer from respecting the notice period in the Act. Employers will still be required to provide notice of group termination to the Employment Standards Officer and any applicable union as soon as possible, and employees will retain their entitlements to individual termination notice or pay in lieu of notice. I am pleased to bring forward these amendments that will both strengthen worker protection and provide flexibility for employers, and which are consistent with action taken by other jurisdictions in response to the pandemic. This concludes my opening remarks. I would be pleased to answer any questions that members may have regarding Bill 20. Thank you.
Thank you very much, Minister Simpson. Members, are there any questions or comments for the Minister? Seeing none. Mr. Clerk, I believe we are now... Oh, Kevin, perfect. Thank you, Mr. O'Reilly.
Sorry, thanks, Madam Chair. I wanted to give committee members a chance first, but I've got a number of questions I want to raise here. First off, I'm just wondering what kind of consultations did the department do in preparing the bill? The Employment Standards Act really represents an attempt to try to balance the rights of workers versus employers. And I'm just wondering what kind of consultation the department did in developing the bill. Thanks, Madam Chair.
Thank you very much, MLA O'Reilly. Minister?
Thank you. The department did a jurisdictional scan across Canada, and we are the only jurisdiction other than Nunavut to contain or to not have the second provision that was discussed tonight related to group terminations. And the first provision came about due to the requirements, as was mentioned in the opening remarks, around the Safe Restart Agreement and whatnot. But for further information on any specifics, I can ask perhaps Mr. Saturnino to provide those details. Thank you.
Thank you, Minister. Mr. Saturnino?
Thank you, Madam Chair. Thank you, Minister. So, due to capacity limitations resulting from the COVID-19 pandemic, we of course wanted to bring these provisions in very quickly and put the legislative proposal in shortly after the pandemic came to play. And so we of course did not necessarily pursue a formal consultation process, but we did consult with other jurisdictions. We consulted with throughout with the federal government, with different FPTs, and this was a matter that was essentially in the early days of the pandemic a very critical discussion point, and it became very clear that as one of the only jurisdictions to not have this in place, that our act was definitely lagging, and so as a result, we of course put forward a proposal that likely we may have expected would have gone through with some of the COVID legislation earlier in the year, but it did not. So it's going before committee at this time. Thank you.
Thank you, Mr. Saturnino. MLA O'Reilly?
Thanks, Madam Chair, and thanks for that. But were there any attempts to reach out to organized labor workers with regard to the changes to the group termination provisions? And if not, why not? Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you. So I'll just repeat what Mr. Saturnino said. No, thank you.
Thank you, Minister. I believe there was a second part to the MLA O'Reilly's question just in regards to why organized labor was not contacted. Thank you.
Thank you. So, as Mr. Saturnino mentioned, there was a sense of urgency around this, and given that this is a common clause around Canada, it was deemed that it was appropriate to move forward as is, recognizing that there's always a consultation period with legislation, thanks to the good work of committees. Thank you.
Thank you, Minister. MLA O'Reilly, do you have a follow-up?
Thanks, I do, but I wanted to turn to the paid emergency leave provisions, Madam Chair, just for a minute. Yeah, I'm sorry, just a comment too that, the work of a standing committee is not a replacement for work that a department should be doing in terms of preparation of a bill that tries to balance rights. But I want to thank the Status of Women Council for their submission. They were concerned about how the paid emergency leave provisions, if and when the bills passed, are going to be promoted by education, culture, and employment, so employees actually know about this. So maybe I could get the Minister to comment on that. Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you. So earlier in the term of this government, there were changes to the Employment Standards Act, and those were publicized through newspapers, through social media, through news releases, and I think they were relatively widely covered. I think this is a similar type of story where we want to ensure that residents are made aware of this. This is, we're doing this in order to help people in times of crisis, in times of public health emergencies, and that's exactly what this is. So we want to get this information out there. I can ask Mr. Saturnino if there's any additional plans for any other type of targeted public promotion. Thank you.
Thank you, Minister Simpson. Mr. Saturnino?
Thank you, Madam Chair. So when we do enact changes to the legislation or we make any changes in this area, we tend to try to use as many different methods as possible in order to get the word out, including direct correspondence and various forms of advertising. So we would, of course, in this respect, if the changes were put into place, a communications plan will be enacted, and we'll follow suit and advertise these changes widely to the various employers, employees, anyone that it does impact. And just with regards to an earlier comment from MLA O'Reilly, just to clarify, the emergency leave is unpaid. So it's not a paid benefit under the Employment Standards Act. So what it does allow is an employee to access unpaid leave so that they will be able to access federal benefits that will become available. And as an example, during COVID, the federal government introduced a number of benefits that would allow employees to access those benefits while taking time off, and the Act would support that by allowing that to occur with employers. Thank you.
Thank you, Mr. Saturnino. Members, are there any additional questions or comments for the Minister? MLA O'Reilly?
Yeah, thanks, Madam Chair. There is the potential to make regulations to extend the emergency leave provisions even after an emergency is over, and I support that. But I'm just wondering, how does the department see that process working, and how quickly would those regulations be brought into place? Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you. I can ask Mr. Saturnino to respond to that.
Thank you, Minister. Mr. Saturnino? Saturnino, you are muted.
My apologies, Madam Chair. In any situation where there's an emergency or a public health emergency, we would, of course, look to act as quickly as we can. Having these provisions in the Act, of course, puts us in a much better position to respond. And even in terms of developing regulations, we would be able to do that and use the processes available to us. But putting it into the legislation and not having to go through a legislative process in this work is definitely beneficial at this point. And thank you.
Thank you, Mr. Saturnino. MLA O'Reilly, do you have a follow-up?
I do have a few more questions I'd like to ask about the group termination provisions in the bill, if I can, Madam Chair. I'm just wondering, right now there's different categories for the amount of group termination depending on the size of the businesses. And I'm just wondering if the minister has any statistics around how many businesses this would actually impact in each of the categories that are currently appear in the Act. Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you, Madam Chair. I know that we do have those statistics with us. I will give somebody a moment to flip to them and I'll hand it off to them. But I know that Ms. Matheson did want to or could perhaps offer some more clarification on the regulations while we do look for that information, if committee would be agreeable to that.
Absolutely. Thank you, Minister. Ms. Matheson?
Thank you, Madam Chair. Just in terms of the amendments to the Act and what they'll allow us to do in the regulations, essentially the changes to the amendments to the Act will allow us to make changes to the regulations that will allow us to react quickly in emergent situations. So for instance, it will allow us to prescribe certain emergencies in the Act, in the regulations. And then it will allow us to further prescribe reasons that will entitle employees to emergency leave or that won't entitle employees to emergency leave with regard to a particular prescribed emergency. It will also allow us to make entitlement to emergency leave retroactive to a date with regard to a prescribed emergency leave. So how that could work with regard to COVID-19 is that it would give us the ability to prescribe COVID-19 as an emergency under the Act and allow us to make emergency leave retroactive to the date to when the emergency was declared in the Northwest Territories. This would allow any employees who may have been entitled to emergency leave during the period of time that emergency leave wasn't available in our Act. It would give them the ability to file a complaint with our office, and we'd be able to investigate if an employee was wrongfully dismissed on that regard. It would allow us to start an investigation and determine whether the employee would be entitled to either termination pay or reinstatement. Thank you.
Thank you very much, Ms. Matheson. And I'll now turn it over to Mr. Saturnino for the data for MLA O'Reilly. Thank you.
Well, thank you, Madam Chair. So with regards to the question, there are approximately 250 businesses that employ less than 50 employees, 78 businesses that employ 50 to 99 employees, 25 businesses who employ 100 to 199 employees, and 15 businesses who employ more than 200, which are the four classifications of employer sizes in the legislation. Thank you.
Thank you very much, Mr. Saturnino and Ms. Matheson. MLA O'Reilly, do you have a follow-up?
I do, Madam Chair. Sorry, I've got 3 or 4 more, and I know everybody's tired, but I feel that I want to try to probe and get a few more things out here, Madam Chair. So in the bill that appears before us, the decision on an exemption is going to be made by Employment Standards Officer. It's my understanding that most of the other jurisdictions across Canada, that decision is actually made by the minister. So why was the decision made to have the Employment Standards Officer handle this rather than the minister who ultimately is accountable and so on? Why is it not the minister that's making the decision? Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you, Madam Chair. The minister is accountable, and it's only Manitoba and the federal government that have the minister make the decision. It's delegated authority in all other jurisdictions, but ultimately the minister is accountable for the actions of the department. Thank you.
Thank you, Minister. MLA O'Reilly.
Thanks, Madam Chair. Yeah, I guess it would be my preference that it would be the minister making the decision. But I want to ask, the decision is to be made by the Employment Standards Officer, but if the workplace is not unionized, how do employees, under the bill as drafted, how would an employee find out that they would not get the group termination notice that they should be entitled to? How would they find out about that? Because if there's no union, the union wouldn't get notified. So how would an individual employee find out about a decision? Thanks, Madam Chair.
Thank you, MLA O'Reilly. Minister?
Thank you, Madam Chair. This doesn't take away from employee rights in terms of what they're entitled to for notice. However, that's a separate section from group termination. And to speak to specifically to group termination, I'd like to ask if Ms. Matheson could handle this one. Thank you.
Thank you, Minister. Ms. Matheson?
Thank you, Madam Chair. It's important to clarify that it is not, so group termination notice is not a direct entitlement of employees. So group termination notice is required to be provided to the Employment Standards Officer, as well as any applicable, or like any employees union that may be affected. The intent of this notice is to allow our office to make sure that the employees affected by the group termination are going to get their legislated entitlements. So typically upon receipt of this notice, we would follow up with an employer and make sure they're providing the appropriate amount of individual notice to employees. It's in large terminations, it's going to affect the workforce in the Northwest Territories. So it's important for our department to have that information if there's going to be a significant change to the labor market in the Northwest Territories. But that this group termination notice is not a notice that's required to be provided to employees. So it's not notice that they're entitled to. Employees under this bill, employees, most definitely, their entitlement to individual termination notice is not affected. So they will still get the notice that they're entitled to based on their length of service under the Employment Standards Act. Thank you.
Thank you very much, Ms. Matheson and Minister. MLA O'Reilly?
Thanks, Madam Chair. Yeah, I guess that the problem is that the individual termination provisions, the maximum notice or severance entitlement is 8 weeks. So an employee could see their work reduced from a notice period of 16 weeks down to 8. So they would have been entitled, not entitled, they would have been given notice, and they would have had 16 weeks of work that they could have carried out. So they could lose, potentially 8 or more weeks of paid employment. And they don't even have an ability to find out about that. So is there not a way to try to do this in a way so that the individual employee can actually find out that the group termination period has been shortened on them? Thanks, Madam Chair.
Thank you very much, MLA O'Reilly. Minister?
Thank you. So this, what we're proposing here isn't a way for companies to shorten their termination notice period and lay people off earlier. If someone doesn't provide proper notice under this exemption and they qualify for the exemption, it's because they were going to lay off employees regardless. This isn't a way to game the system. I can ask Ms. Matheson for some more detail, though. Thank you.
Thank you very much, Minister. Ms. Matheson?
Thank you, Madam Chair. Again, as the Minister said, I would stress that this provision would only be used in unexpected situations beyond the control of an employer. So, in the context of the pandemic that this kind of gap in our legislation came to our attention, we foresaw situations where an employer might be forced to cease operations with little to no notice. And it caused us to kind of ask how that would work in terms of how our act read. And at this point in time, there's no mechanism in our act that makes it okay for an employer to not provide the adequate amount of group termination notice to our office. Like like I said previously, individual notice in the Act is allowed to be provided in terms of working notice, as MLA O'Reilly alluded to, or if working notice isn't able to be provided, there is an entitlement to pay in lieu of notice. However, that's not the way that the group termination provision works. And so, yeah, similar to what the minister said, these types of situation where this provision would apply would be situations that are out of the control of an employer. So like a destruction of a work site, or an operation having to close down because of a public emergency. And so there's situations where unavoidably employees wouldn't be able to continue to work. Thank you.
Thank you very much, Ms. Matheson and Minister. MLA O'Reilly.
Thanks. Look, I don't want to get into a debate here about this, but an employee could lose a significant number of weeks of employment because of a group termination period being shortened, and they wouldn't even know about it. And I just don't think that that's fair or the right way to do this. But I just have, I think, maybe one other question here, and I'm wondering why there's no time limit in the bill that's before us for an employment standards officer to make a decision. Clearly, if it's some kind of an emergency, an employer wants to get some certainty and move forward. And if you're an employee, you'd like to know about getting laid off. Why is there no time limit in which a decision has to be made? Thanks, Madam Chair.
Thank you very much, MLA O'Reilly. Minister?
Thank you, Madam Chair. Just to clarify again, if you're an employee, you have a right to be notified of
individual.
And this bill does not affect that. There are no changes to that. So individual employee rights to notice are not being affected by this bill. And I just want to make sure to everyone who's listening that they understand that. I can ask Haley for some clarification, though. Thank you.
Thank you very much, Minister. Ms. Matheson.
Thank you, Madam Chair. I can assure you that when we receive these types of notice that these types of situations are our priority in our office. There's not anywhere else in our act that legislates an amount of time that we need to make a decision. But I can assure you that when these types of scenarios, arrive on our doorstep, these are our main focus and our main priority. It is our office's responsibility to enforce and administer the Employment Standards Act, and we take that responsibility very seriously. I think that's it. Thank you.
Thank you very much, Ms. Matheson and Minister. MLA O'Reilly, do you have any additional follow-ups?
No, Madam Chair, just a couple of quick comments if I can. I don't think that this bill achieves the appropriate balance between workers' rights and an employer's rights. And I'm very concerned that an employee may not even find out about shortening of a group termination notice having been given by their employer, and that they could potentially lose weeks of paid employment as a result of this. And I understand the potential loss for an employer, but I just don't agree that we found the right balance because workers could lose weeks of paid employment as a result of this provision and not even have a right to know about it. Thanks, Madam Chair.
Thank you very much, MLA O'Reilly. Minister, would you like the opportunity to respond?
Yes, I want to note that the Employment Standards Act, as is, does not give authority to the government to force employers to stay in business and keep people employed. We're not taking away an authority to do that. If someone gives notice of termination, group termination, and it's too short right now, they have to be punished under the Act, regardless of why that notice was shortened. If there's a contractor working at a mine and without any notice the mine shuts down, goes into care and maintenance, and that contractor has to lay off everyone that day because there's no other work, there's no other contracts, that 100% of the business is at that mine, And that contractor then gives notice to the Employment Standards Office that they can't wait the 16 weeks because they have to lay off everyone now. We have no choice but to punish them. And this is a way to remedy that. It's not a way to reduce, wages for employees. Thank you.
Thank you very much, Minister, and thank you very much, members. Are there any additional comments or questions this evening? Seeing none, I believe we are now concluded with this stage of our review. Mr. Clerk, are there any requests from the public to appear before committee this evening?
There were no submissions from the public received, Madam Chair.
Thank you very much, Mr. Clerk. Seeing as there are no further general comments or witness presentations, does committee agree to proceed to a clause-by-clause review of Bill 20, an act to amend the Employment Standards Act? MLA Bonnet Rouge?
Pardon? Is that? Madam Chair. No, Madam Chair, committee requests additional time to review the bill.
Thank you very much, committee. As such, the clause-by-clause review of Bill 20-19(2), an act to amend the Employment Standards Act, will be conducted at a later date. This concludes the proceedings for this evening. Minister and your staff, I'd like to very much thank you for your time this evening, and we will follow up with your office shortly. Thank you.
Thank you, Madam Chair. I also want to thank my staff. I want to thank the committee, and I want to thank the non-committee members who also participated. I value the input from all the members. So everyone take care and have a good night.
Thank you, Minister Simpson. Have a wonderful evening and stay warm. I agree. Just a second.